Supreme Court judgment ready. Start. It now becomes the duty of the court to instruct you as the law governing this case and what I shall say to you on that subject you must be governed by. The court proceeds as the trial of an action for the purpose of, among other things, determining the law in the case and advising the jury as to what the law of the case is and also passing upon objections to evidence which may be offered in support of the issues joined and seeing the improper evidence is included from the jury's consideration so that they may readily see the issues and apply the evidence that is adduced in support of the issues or the contradict the issues. The jury are the judges of the facts and with the jury rests the determination of what the facts in issues are. It is peculiarly the province of the jury to determine from the evidence and the natural and logical inferences to be drawn from the evidence what the facts involved in the case are, and by their verdict they determine the facts, and with their finding the court has nothing to do except as I have hereto said to see that they are properly instructed and only consider proper evidence parachange. If the court in making any ruling during the trial of this case has said anything from which the jury infers that the court has any opinion as to how this case ought to be decided, I now charge you to disregard what the court said in the behalf. I have no recollection of having said anything of that nature, but out of an abundance of caution I now say to you that it is your duty to exercise that independent judgment upon the evidence in the light of these instructions, and by your verdict determine what the facts in issues are parachin. A fact is said to be in issue when it is asserted on one side or denied on the other, and the fact in issue are to be found in the pleadings in the case. There is a common error which calls arguments of counsel to the jury before the close of the evidence, the pleadings of counsel. That is incorrect. Those statements made by counsel to the jury in explanation of the evidence and in behalf of their respective contentions are two arguments of counsel, while the pleadings are the written statements of the parties to the action filed in the action before it is submitted to the jury and contain the facts which it claims exist in the case. In the action, Sable and his younger brother Thomas are the plaintiff and John William Glenn is the defendant, and the pleadings in this case consist of the petition, the answer thereto, and the amendment to the answer, and a reply to the amendment to the answer. Parachange. Keeping in mind what I have told you constituted an issue of fact, namely where a fact is asserted on one side and denied on the other, that there an issue is said to be joined which the jury must determine. I now say at this point that wherever one of the parties admits an averment which the other party makes, the jury may take for the purposes of the action the admission to be true and the fact established, so that what the defendant has admitted in his answer to the petition you may take as true, namely that on the first day of May he sold and assigned to Shabal brothers at Pittsburgh for the agreed consideration set both in the contract in evidence here. The 4 or 5 leases described in the petition together with the wells, powerhouses, tanks, road, tubing machinery, fixture, and other personal property located thereon, and further that he was not to have all the while production from state leases up to June 1st last, and further that the defendant at that time he made said sale and transfer to the plaintiff know that there were only 20 such wells located on said premises, but all other statements of the plaintiff the defendant denied, and by he denied cast the burden of proof upon the plaintiff, so that before plaintiff would be entitled to recover anything in this action, they would have sustained the burden of proof and make out their case by evidence to the degree of certainty that I shall hereafter refer to. Parachin, you are the sole judges, gentlemen, of the credibility of the witnesses, that is to say, you are to determine by the exercise of your judgment how far you will believe the witnesses in their testimony. Parachin, the evidence in this case consists of the sworn testimony of witnesses given on the stand, as well as department of witnesses, parts of which were read to you, and also some papers which are called documentary evidence, which were admitted for your consideration. And in finding the issues in this case, you should consider all these classes of evidence and compare them and consider them fully, giving due weight to all the evidence and reaching a conclusion from the evidence, and as said before, the natural and logical interference to be drawn from the evidence, being the judges of the credibility of the witnesses, you are at liberty to believe of the witnesses, you are at liberty to believe or disbelieve part or all the testimony of any of the witnesses. The witnesses were under oath while testifying, and the presumption is that they were telling the truth. But you are not required by law to give full credence to everything that a witness may say simply because he is under oath, because the witness may be mistaken, or his interest in the result of the controversy may incline him to color his testimony, sometimes unconsciously, and other considerations of like character may make it appear proper to you not to give the full degree of credibility that the language of the witnesses imparts. The testimony of the witnesses should be tested by you. That is to say, you should consider the witnesses while upon the stand, his candor and fairness of lack of it, his willingness or unwillingness, the readiness with which he testifies, the circumstances to which he testifies, the opportunity that he may have had of knowing that to which he testified, to his bias or prejudice for or against either party, if any was shown, and his interest in the result of the controversy, if any, and all such considerations as these which may enable you to determine how far you ought to accept the statements of the witnesses in asserting the facts that are submitted for your consideration and determination. Stop.